Hi, my name is Tim and I'm a registered civil celebrant with the Attorney General in Victoria. Today I would like to talk to you about the Notice of Intended Marriage and the required steps that you need to take in order to complete this document successfully. The Notice of Intended Marriage is a requirement under the Australian Marriage Act of 1961 for any couple wishing to be married under Australian law. A Notice of Intended Marriage is readily available as a download from the Attorney General's website or from a civil celebrant. Before you complete a Notice of Intended Marriage, you need to make sure of at least three things. 1, that you are over the age of 18. 2, that you are not directly related to the partner that you plan to marry. And 3, that you are not currently married to anyone else. You will also need to ensure that you have several forms of ID. Firstly, you may produce a birth certificate together with a driver's licence. Secondly, you may produce a passport. And thirdly, if you have been married before, you must provide evidence that you are now free to marry again. This evidence would be in the form of a decree absolute or a divorce order, or you may even have a death certificate, depending on how your previous marriage ended. Once you have determined that you are now eligible to complete the Notice of Intended Marriage, you may proceed. Firstly, the Notice of Intended Marriage can only be submitted to either a denominational or a civil celebrant. The usual step is to select your civil celebrant first, and then, together with your civil celebrant, complete the paperwork. There are many instances when you will be unable to meet with the civil celebrant to complete your paperwork. These are usually to do with distance and perhaps even overseas marriages. In these cases, it's perfectly okay for you to complete the Notice of Intended Marriage on your own, but remembering that you will at some stage have to submit your Notice of Intended Marriage to a civil celebrant or a denominational celebrant of your choosing. When you first open up your Notice of Intended Marriage, you will see a number of boxes. The top left-hand box is reserved for details of your ceremony to do with the time, the date, and the place of where you plan to have your wedding. The central box up the top is reserved for details of which celebrant you will be booking for your wedding day. Then you will see a box on the right-hand side which is reserved for the Registry of Marriage. The two boxes below are reserved for simple details to do with the couple that are going to get married. The box on the left is for the bridegroom, commonly known as the groom, and on the right is the box reserved for details of the bride. The two boxes on the lower quarter of the page are reserved for couples who have been married before. You will notice that many of the details that are required are very, very straightforward, with the exception of a couple of points. Your conjugal status, if you have never been married before, you need to write never validly married. If you have been divorced, you would write divorced. Also, with your parents' names, it's very important that if they are no longer living, that you put in brackets the words deceased. It is also very important that you use your parents' full names, first, middle and last names, and specifically with your mother, that you use her maiden name. In the lower quarter of the page, there are specific details that are to do with your previous marriage that are required. You need to know things like the number of previous marriages, the year of each previous marriage, the year of birth of your children and how many have been born alive, how your last marriage was terminated, and also the date on which the absolute order became effective. On the back of the Notice of Intended Marriage, at the very, very top, you will see a question that asks you if you are directly related to the person that you are about to marry. If you tick yes, you must then provide details of the exact relationship between you and that person. Under Australian law, it is perfectly legal to marry your first cousin onwards. If you are unsure of the validity of the relationship of the person that you are about to marry, you must seek advice from a civil celebrant or a denominational celebrant. Once you have completed the form, you then must sign it in front of a witness. A witness may be any person that is currently listed on the Statutory Declarations Act of 1959. Once you have had your signatures witnessed, you then may proceed to submit your notice of intended marriage to your selected celebrant of choice. This must be done no later than 30 days prior to the date on which you intend to be married. In other words, there must be 30 days that are allowed to elapse between the date that the celebrant receives your notice of intended marriage and the date on which the marriage will be solemnised. The lower section of the last page of your notice of intended marriage is designed for your celebrant to collect details regarding your ID and the information that you have provided to prove that you are eligible to be married. At the very bottom of the notice of intended marriage, there are two small tick boxes which will be filled out by your civil celebrant once they have given you the required brochure Happily Ever Before and After, which is also a requirement of the Australian Marriage Act of 1961. The Happily Ever Before and After brochure is simply an instructional booklet for couples who are planning to get married and who are seeking some extra services or extra advice in the lead up to their marriage.